I'm starting a new feature. I'm going to call it Mailbag Monday, and I'm going to go over a couple of the emails that I got over the last week and talk about some of the things the questions that people raise, and hopefully get back into the Abby Zorner case here in a little bit. But I wanted to address the fact that, I do answer emails and I actually do discuss things that come up in email. That's where a lot of the ideas for some of the videos come from. So, again, if you have a question and you would like to have an answer, I do tend to look at email quite a bit. So, with that introduction, hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. So the first question comes in and it regards the what Law and Crime is calling the House of Horrors case. And these are the screenshots that were sent to me, and he says, "Your thoughts." And the issue that was raised on News Nation, which is what this video is about whether it was right to give out the name and address and current location of the victim in this case to the defense. And that raises a really interesting question for a number of reasons. First of all, in most cases, courts are very careful to protect the identity of someone who has been a victim in a crime. And assuming all of the facts stated by the prosecution and the victim are true, which is an assumption and may not be true, here's what that particular case concerns. A 31-year-old man who was kept prisoner inside a room inside his mother's house for 20 years and starved to the point where, at the time that he set the house on fire in order to get rescued, at that time he only weighed 70 pounds. Now, I can hardly imagine the kind of torture that he must have endured. Well, once he was discovered, once he was brought out, once he was freed from that captivity, he relocated, and that information was kept from the defendant. And of course, she was charged with the crime of essentially kidnapping, false imprisonment, all kinds of stuff. And those are not unserious allegations. You can't just decide that somebody doesn't need to have any freedom and put them and lock them in a closet somewhere, which is sort of what this woman allegedly did. So the issue comes up as to whether or not that individual's identity and the name that he's using and all this other stuff should come to the defense so that they can prepare for trial. And the judge answered yes. And the reason is because of the Confrontation Clause of the United States Constitution. And here's what the Sixth Amendment says: in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted by the witnesses against him, to have compulsory process for obtaining his own witnesses, and assistance of counsel. So that's the right that's granted to all of the defendants under the Constitution's Sixth Amendment. And in that particular case, in the House of Horrors case, if they can't go and talk to this man, if they can't get some way to confront him and find out information about him, he might be, for example, running a scam somewhere else where he claims to be a prisoner. I don't think that's rational or likely, given the amount of publicity and the fact that the guy was at 70 pounds when he was rescued. But okay, let's assume for the sake of argument that that was necessary. It's probably the right thing to do. Now, my guess is that because of the victim and the defendant's relationship, the judge will have made a little bit of a different order in terms of what he's allowing. So, generally speaking, what he is allowing is he's probably allowing them to have that information available to defense counsel, but defense counsel cannot, under penalty of probably disbarment, I would think at this point, given the seriousness of the crime, he can't reveal that information to the defendant. Not because there's any real likelihood, I think, that the defendant is going to be able to get off, but because the defendant might know someone on the outside who could go and harm this guy and keep him from being available to testify at trial. So again, it's a situation where the judge is trying to balance the rights of the parties. Yes, you get to have this information. No, you can't share it with the defendant. And if you do, you're going to be in big trouble because you'd be ignoring an order from a court that you are required to obey because you're an officer of the court. And if you leak that information to the defendant, you can look for some kind of bar sanction up to potentially including disbarment. So we'd hope that, nobody would be so stupid as to do that. The next question that arose was this one. Interested in your critique of defense and the way Judge Ralph M. Ramirez handles it. Day 3, end of day 4, beginning, if you watch more, there at full 8-hour days. The witness on the stand is Detective Fredericks, and the defense is supposed to be cross-examining. And I would note the part of this that I watched indicated that the defense is doing a very bad job. It appears that the defender is a young man and a young lawyer and probably hasn't had a lot of experience asking questions and doing it, under the gun, so to speak. So he has another lawyer there with him to whisper in his ear about what to do. So the judge actually stops the cross-examination on day 3 at about the 7:35 to 40-hour mark. On Law and Crime, I found it closer to the 8-hour mark, and sends out the jury after the defense says there were 100 more clips to go through. So let's watch just a teensy bit of that video real quickly here.
We'll have exhibits all the way to I have exhibits to all the way to 590, which are dated August 18th, August 20th. Medical picks her up from her home, brings her back to his apartment.
So you've got about 100 more of these?
Yes, sir.
Let me talk to the attorneys. Folks, why don't you have a little recess here? Those of you who have tried cases in front of me may have heard me cite 906.11 of the Wisconsin statutes, which allows a court to exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And it names 3 things. It lists 3 things. Make the interrogation and presentation effective for the ascertainment of the truth. Avoid needless consumption of time. And that's A and B. And C says protect witnesses from harassment or undue embarrassment. Detective Fredericks seems to be doing okay. I don't think he's getting harassed or embarrassed. But on the other hand, it seems that A and B may be coming into play here, Mr. Galaviz. Again, you said that there was an objection. I overruled the objection because you said you wanted the jurors to see how Mr. Paul and Ms. Pavlons were getting along, that they were okay. And these don't seem to be showing that. It seems to be that they're showing the individuals coming and going. I mean, granted, there isn't any dispute or fight or anything between the two of them, but they're coming and going separately from each other. And I'm not quite sure how the reason that you proffer them is being accomplished here. Tell me a little bit more, please.
Well, again, the reason I am offering this to show how Stephanie would voluntarily come to his apartment, voluntarily enter his apartment, didn't voluntarily exit, how she was dressed, because some of these clothing, I think at least part of this clothing was located in Matt's closet when it was searched on September 17th. It kind of shows that every time Matt would come from his orthopedics appointment, he would change his clothes. The state made a big deal out of it that on August 23rd, when Matt came from orthopedics, he entered the building and changed his shirt. Like that was some big deal. Like he had done something that caused him to change his shirt when he arrived on August 23rd from orthopedics. And I was just showing the jury that he does that every single time he goes to orthopedics. He comes, changes his clothing, and you can see him where he changes his clothing on all the dates that he goes to orthopedics. It's not.
It's going to take you 100 more pictures to do that?
No, I can
Or
cut it.
pictures or videos?
I'll be able to cut it down, Judge.
By 30,
I'll be able to do it this tonight. I can do it first thing in the morning.
I'm going to release our jurors. Right, I'm going to have to come back and I'm going to have to go. And I suggest you rethink how you're going to do it.
Right.
I'm
Also,
not going to tell you you can't do it, Mr. Galaviz, but I'm going to suggest that you rethink how you're going to accomplish that. So we will bring the jurors back in, and I'm going to excuse them for the night.
And the next day, the judge follows up. So let's look at what really happens here in terms of whether it modifies this lawyer's behavior or not. Watch what happens the first few minutes of day 4. I think you'll find it, at the very least, interesting from the standpoint of how the lawyer is conducting the cross-examination.
Came up at the end of the day yesterday. I cautioned Mr. Galaviz about his intent to demonstrate what he had mentioned yesterday. And as I said, I don't want to tell people how to do their job, and I'm not going to do so. But I don't want to continue where we were. I don't know what you got planned, Mr. Galaviz, but we'll see what happens as we move forward. Please be seated, and once again, state your name, please.
Brian Fredericks.
All right, Mr. Galaviz.
thank you, Judge. Good morning again, Detective.
Morning.
I believe last night or yesterday we had finished with exhibit
485.
45. Exhibit, or do you need me to refresh your memory at all?
Yes, please.
Okay. Well, exhibit number 479 was, if we can display this to the jury. Exhibit number 479 depict Stephanie leaving on August 18th at 9:15 in the morning, Willow Parks apartment, true?
That is correct.
That was the north entry, true?
Yes, sir.
Exhibit number 482. If you can see that. Same date, August 18th, 2022, 9:15 in the morning. It depicts Mr. Paul leaving Willow Parks, true?
Yes,
He leaves shortly after Stephanie, true?
correct.
So it's 9:15, and again, the record yesterday indicated that on that day, Mr. Paul had an appointment at orthopedics, true?
That is what you told me, yes.
Exhibit number 486, for that particular day, I stopped it. It has August 18th, 2022, approximately 3:25. Do you see that exhibit on your monitor too?
Yes, sir.
It depicts apparently Mr. Paul returning to Willow Parks.
Yes.
He seems to be dressed different from when he left, true?
Yes.
Did you find it unusual at all?
Seems to be consistent.
Based upon your investigation of this case, do you know when Miss Pavlin's returned back to Willow Parks? When the next day she was there?
I believe it was August 20th.
And I think her mother testified to that, correct? The last time she saw her was around August 20th?
Yes, sir.
And then Mr. Paul had picked her up, true?
Correct.
I'm showing you it's marked as exhibit number 490.
Your Honor, I'm going to object. First of all, this shouldn't be shown to the jury yet. And I think he needs to lay the proper foundation.
What is 490? I don't know what 490. Let me. All right. I'll sustain the objection at this time.
So at least to me, it didn't seem like anything that Judge Ramirez said to him altered his approach. After he got the detective to admit that he didn't see anything out of the ordinary about him changing his shirt, I think he had everything that he needed at that point. But instead, he keeps going back to these videos. And again, rule number one, don't annoy the judge. If you annoy the judge, you're going to have a bad time of it. And he is annoying the judge. Secondly, instead of asking tight, direct, leading questions to get this guy to admit what we all know he's going to admit, he asks open-ended questions as if he was doing a direct exam. And that's never a good idea. Well, not never, I guess, because the cross-examiner in the Murdaugh case certainly used some open-ended questions. But generally speaking, it's a much better practice to use closed leading questions so that you know there's no room for them to run. And if they don't answer it, you come back and say, it's not my question. Listen to my question. Here's my question. And pretty soon you're going to get the judge to help you. He's going to say, look, it's a yes or no question. Answer it yes or no, or whatever it calls for. So I think in this particular case, the lawyer is probably not doing as effective a job for this Matthew Paul as he probably should. I don't really have any interest or time to do anything on that trial, but because people send me these things and they have teachable moments in them, I like to bring them out and at least let you know I am paying attention and I am looking at your emails. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.